Before we begin, a quick and important disclaimer. The information provided in this video series is intended strictly for educational and entertainment purposes only and does not constitute professional legal, financial, or tax advice. Family law, asset division, and child custody regulations are highly complex and vary drastically from state to state, county to county, and even courtroom to courtroom. The case studies, historical trends, and potential outcomes discussed here are meant to illustrate general concepts and should never be taken as a substitute for professional counsel. You must conduct your own due diligence and retain a licensed family law attorney who practices in your specific jurisdiction to understand your unique legal standing. Any actions you take based on the information in this deep dive are taken entirely at your own risk. Imagine dedicating 2 decades of your life to building a career, a home, and a family in the Pacific Northwest, only to discover that a completely invisible geographic line is about to dictate the entire financial trajectory of the rest of your life. Every single day, men residing in the Portland metropolitan area cross the Columbia River into Vancouver, Washington, for work, recreation, or to visit friends, completely unaware that this simple river separates 2 entirely different legal universes. If you are a man facing the end of your marriage in this region, the system is an intricate labyrinth of contradictory statutes. Washington is a community property state, while just across the bridge, Oregon is an equitable distribution state. This is not merely legal trivia. This is the difference between keeping your retirement intact or writing a devastatingly large check to your soon-to-be ex-spouse every single month for the next 10 years. Historical trends show that men who walk into a divorce proceeding without fundamentally understanding the specific judicial temperament of their local county court often lose access to their children and suffer a catastrophic drop in their standard of living. There is a specific, completely legal strategy to protect your assets and establish a commanding position before the divorce papers are even served. However, if you make the one emotional mistake that 90% of men make in the first 48 hours of a marital separation, you forfeit your leverage forever. I will reveal exactly what that irreversible mistake is and how you can strategically avoid it a little later in this comprehensive analysis. Today, we are dissecting the chaotic, high-stakes reality of divorce for men in the United States Pacific Northwest. The promise of this masterclass is simple but profound: to strip away the confusion, the emotional manipulation, and the courtroom myths, and replace them with cold, hard, actionable education. This series solves the exact problem keeping you awake at night right now, which is the paralyzing fear of the unknown. We are going to break down the mechanics of survival, asset preservation, and maintaining a meaningful paternal relationship with your children in jurisdictions that are often historically hostile to men. We will explore the harsh realities of spousal support, the division of complex compensation packages, and the psychological endurance required to survive this process intact. To understand the battlefield, we must first analyze the unique economic landscape of the Pacific Northwest. This region is home to massive technological and corporate powerhouses like Amazon, Microsoft, Boeing, Nike, and Intel. Therefore, modern divorces in places like King County, Washington, or Washington County, Oregon, rarely involve just a simple division of a checking account in a family home. They involve incredibly complex corporate compensation structures, specifically restricted stock units, stock options, and deferred compensation plans. If you are a male tech worker in Seattle, you might assume that the unvested restricted stock units you were granted for your future performance belong solely to you. You would be dangerously mistaken. In Washington state's community property framework, courts apply highly specific formulas, such as the time rule, to determine exactly what percentage of those unvested shares belongs to the marital community. We have seen historical case studies where men failed to aggressively value and separate their restricted stock, resulting in courts awarding half of their future unearned wealth to their ex-spouses simply because the initial grant occurred during the marriage. This masterclass will provide a detailed roadmap on how financial experts analyze these assets, the potential outcomes of aggressive litigation versus mediation, and how you can work with your legal team to shield your future earning capacity. Equally treacherous is the landscape of spousal support, heavily dependent on exactly where you file. Let us look at Oregon. Unlike Washington, which generally views spousal maintenance as a temporary rehabilitative measure to get a lesser-earning spouse back on their feet, Oregon has historically been known to award indefinite or compensatory spousal support in long-term marriages. If you are a high-earning man in Multnomah County who has been married for over 10 years, the historical trends suggest you are walking into a massive financial liability. The courts will meticulously analyze the standard of living established during the marriage, your earning capacity, and your spouse's contributions to your career. Many men mistakenly believe that if their wife has a college degree and is perfectly capable of working, the court will simply force her to get a job. This is a fatal misconception. We will explore case studies detailing how vocational evaluations are utilized in these proceedings, how imputing income works, and the step-by-step strategies legal teams use to argue against permanent alimony. You will learn the critical difference between transitional, compensatory, and spousal maintenance support, and how to identify which one your spouse's attorney is likely to weaponize against you. Furthermore, we must address the most emotionally devastating aspect of this process: child custody and the concept of the primary residential parent. The Pacific Northwest is culturally progressive, and while the law officially states there is no gender bias in determining child custody, the reality experienced by countless men tells a very different story. The historical trend in many county courts is to default to the mother as the primary caregiver, unless the father can definitively prove otherwise. This brings us back to the fatal mistake I mentioned earlier in the hook. The absolute worst thing a man can do in the initial stages of a divorce is to pack a bag and voluntarily move out of the family home to defuse tension. By doing so, you are instantly establishing a new status quo. You are legally demonstrating to the court that the children are perfectly fine living primarily with their mother, and that you are comfortable being a weekend visitor. Courts prioritize stability for the children above all else. If you move out, even for just a few weeks before filing, the court will likely look at that established routine and codify it into a temporary order. That temporary order then dictates the permanent parenting plan. You have just surrendered your leverage, your daily access to your children, and drastically increased your child support obligations, all because you thought you were doing the polite thing by leaving. We will dissect the mechanics of temporary orders, how to establish yourself as the primary caregiver on paper and in practice, and how to navigate the explosive environment of remaining in the marital home while the divorce is pending. You will learn how to document your parental involvement, how to counter false allegations designed to remove you from the home, and how to position yourself not just as a financial provider, but as an indispensable, equal parent in the eyes of the law. Once you have successfully established your physical presence in the marital home and documented your active, daily involvement in your children's lives, you are immediately thrust into the next, arguably more brutal phase of the dissolution process. This is the financial freeze. In both Washington and Oregon, the exact moment a petition for dissolution of marriage is officially filed and served, a statutory financial restraining order automatically goes into effect. This is a crucial piece of the legal machinery that you must understand conceptually to avoid devastating missteps. This automatic order fundamentally paralyzes the marital estate. It prohibits both parties from selling, transferring, assigning, or hiding any assets. It stops you from changing the beneficiaries on your life insurance policies, dropping your spouse from your health insurance, or draining joint bank accounts. On paper, this is designed to maintain the status quo and prevent financial sabotage. In reality, historical trends demonstrate that the party who files first often dictates the immediate financial reality of the next 6 months. Imagine if it is a random Tuesday morning in 2026. You are driving to your office in downtown Seattle or Portland, completely unaware that your spouse filed for divorce the previous afternoon. You stop for a coffee, swipe your debit card, and it is declined. You log into your banking app and see that the joint savings account, which held the liquidity you relied on for emergencies and daily operations, has been completely emptied down to a zero balance. Because you were not legally served yet, the automatic restraining order had not technically constrained your spouse from securing those funds in a separate, newly opened account. Now you are effectively starved of capital right as you need to retain a high-caliber legal team. This is not an anomaly. This is a remarkably common scenario analyzed in numerous financial separation case studies. The courts will eventually sort this out during the property division phase, often ordering those funds to be credited back to the marital estate, but that judicial reckoning could be a year away. Right now, in the immediate present, you are fighting a multi-front war with zero liquidity. This illustrates exactly why understanding the timing of filing and the necessity of independent, legally established financial reserves prior to the initiation of proceedings is paramount for your survival. Let us examine a practical case study based on typical outcomes in the Pacific Northwest tech sector. Consider a man named Michael, a senior systems engineer living in Bellevue in the year 2026. Michael has been married for 9 years. He earns a substantial base salary and receives lucrative yearly stock grants. When his divorce initiated, Michael assumed the process would be a straightforward division of their house equity and their liquid cash. He fundamentally misunderstood the brutal and invasive nature of the legal discovery process. Discovery is the formal mechanism where both sides are legally compelled to surrender every single document detailing their financial existence. Michael was served with a request for production that demanded 10 years of bank statements, credit card logs, mortgage applications, tax returns, and the complete internal vesting schedule of his corporate compensation package. Historical trends show that men who attempt to manage this phase without specialized forensic financial guidance almost always surrender massive leverage. During this discovery phase, Michael made a critical error regarding his digital assets. Like many men navigating the economy in 2026, Michael had accumulated a moderate portfolio of cryptocurrency over the years, holding Bitcoin and Ethereum on a decentralized hardware wallet. Fearing that his spouse would take half of an asset he actively managed and researched himself, he omitted the wallet from his initial financial disclosures, transferring the assets to a new cold storage address. He assumed the blockchain was anonymous and the court would never find out. This is a catastrophic miscalculation. Modern forensic accountants employed by opposing counsel do not need to hack your cold wallet. They simply look at your historical bank statements. They found the original fiat transfers from his checking account to a major crypto exchange 3 years prior. When Michael could not produce the corresponding digital assets or a record of their sale, he was caught committing perjury on his financial declaration. Potential outcomes in situations like this are severe. Judges despise being lied to. In equitable distribution states like Oregon, and even in community property states like Washington when dealing with hidden assets, the judge has the broad discretion to award the entirety of the discovered hidden asset to the opposing spouse as a sanction for financial deception. Furthermore, his credibility was permanently destroyed, which negatively impacted the judge's view of him in subsequent child custody evaluations. This brings us to the complex battlefield of restricted stock units and deferred compensation, which forms the bedrock of wealth for many men in the Pacific Northwest. If you are awarded unvested shares today, but they require you to remain at the company for the next 4 years to actually receive them, who do they belong to if you divorce tomorrow? Your spouse's legal team will argue that because the grant was awarded based on work performed during the marriage, the community estate is entitled to a massive portion of the future vests. Your legal team must meticulously analyze the exact language of your corporate grant documents. Was the stock awarded as a bonus for past performance, or is it an incentive for future retention? If it is for future retention, meaning work you will perform after the legal date of separation, historical case studies indicate you have a strong argument to shield those future vests from the marital estate. However, this requires bringing in specialized compensation experts who understand the intricate time rule formulas used by the courts. You cannot expect a general practice family law attorney to effectively litigate a complex corporate equity division against a highly motivated opposing counsel. While you are navigating this terrifying financial audit, you are likely still living under the same roof as your spouse due to the child custody strategies we discussed previously. This creates an environment of intense, suffocating psychological pressure. You are sleeping in the guest room, hyperanalyzing every interaction, while both of your legal teams are actively trying to dismantle the other's case. Every text message you send, every offhand comment you make in the kitchen, and every frustrated sigh is being documented and potentially forwarded to opposing counsel to paint you as erratic, unstable, or financially controlling. Your home is no longer a sanctuary. It is an active surveillance zone. The sheer endurance required to wake up every day, go to work, perform at a high level, and then return to a hostile living situation without reacting emotionally is immense. Many men crack under this pressure. They send angry emails, they engage in loud arguments, or they attempt to preemptively cancel credit cards out of spite. These actions are immediately weaponized. But there is a specific judicial off-ramp that the court system will heavily push you towards, promising to relieve this pressure and save you thousands of dollars in trial fees. They will tell you it is the civilized way to end your marriage. They will call it alternative dispute resolution. But what they will not tell you is that walking into that specific room without a profound understanding of the psychological traps waiting inside is the fastest way to sign away your parental rights and your financial future in a single afternoon. Tomorrow, we are going to expose the hidden architecture of the mediation process and exactly how opposing attorneys use exhaustion tactics to force you into a devastating settlement. Mediation is universally marketed to the public as a cooperative, peaceful alternative to the bloodbath of a courtroom trial. In the Pacific Northwest, courts in counties like King, Pierce, and Multnomah are so backlogged with litigation in the year 2026 that they legally mandate you to attempt mediation before they will even assign you a trial date. You are told that a neutral, highly trained professional will sit down with you and your spouse to help you find common ground, allowing you to maintain control over your own destiny rather than handing your life over to a judge. This is the sanitized brochure version of the process. The historical reality, backed by countless case studies of men who have walked out of these sessions financially decimated, is that mediation is a high-pressure, unregulated psychological endurance test. To survive this phase, you must fundamentally understand the true motivation of the mediator. Mediators in high-asset divorce cases are typically retired judges or senior family law attorneys who charge anywhere from $400 to $800 an hour. Their primary objective is not fairness. Their objective is not justice. Their singular professional metric for success is securing a signed settlement agreement by the end of the day to clear the court docket. To achieve this, they will rely on a technique known as shuttle diplomacy. You will not be sitting in a circle singing campfire songs with your spouse. You will be placed in a small, windowless conference room or a virtual breakout room with your attorney. Your spouse and their attorney will be placed in another room down the hall. The mediator will then spend the next 8 to 12 hours walking back and forth between these two rooms, carrying offers and counteroffers. Imagine if you are a man named David, a commercial architect living in Portland in 2026. David walks into a mediation session at 9 in the morning, holding a reasonable, mathematically sound proposal for a 50-50 split of the marital estate and a joint legal and physical custody arrangement for his 2 young daughters. He is optimistic. He assumes logic will prevail. By 10:30, the mediator enters David's room with the first counteroffer from his spouse. It is an absolute insult. The opposing counsel is demanding 80% of the retirement accounts, sole decision-making power for the children, and a spousal support figure that would leave David unable to afford a 1-bedroom apartment. This is not a mistake. This is an aggressive negotiation tactic known as extreme anchoring. Opposing attorneys use this tactic to immediately shift the goalposts of the entire day. Suddenly, David is no longer negotiating to achieve a fair 50-50 split. He is desperately negotiating to avoid total ruin. As the day drags on, the true exhaustion tactics begin. By 2 in the afternoon, progress is moving at a glacial pace. David has spent 5 hours sitting in a room, paying his attorney $500 an hour, paying half of the mediator's $600 an hour fee, and achieving absolutely nothing. The financial burn rate for this single day is astronomical. By 4 in the afternoon, the psychological warfare reaches its peak. This is when the mediator deploys their most effective tool, the fear of the unknown. The mediator will come into David's room, look him in the eye, and give the infamous trial speech. They will tell David that if he takes this case in front of a judge in Multnomah County, he might lose everything. They will cite historical trends of judges awarding massive compensatory spousal support. They will remind him that a trial will cost an additional $50,000 in legal fees and take another year to complete. Here is the most critical dynamic you must understand about mediation. The mediator will always exert the maximum amount of pressure on the party who appears most willing to be reasonable. If your spouse is acting entirely irrational and refusing to budge, the mediator knows they cannot force her to compromise. Therefore, to get their successful settlement, the mediator will pivot and put all of the pressure on you, the logical man, to give up just a little bit more to close the gap. They will systematically wear you down. By 7 in the evening, David is mentally exhausted. His blood sugar has crashed, and he is sick to his stomach at the thought of spending another $50,000 on a trial. He just wants the nightmare to end. His spouse's attorney slides a modified proposal across the table. It is significantly worse than David's original fair offer, but slightly better than the morning's insulting anchor. It involves David giving up a massive portion of his home equity and agreeing to a visitation schedule that reduces him to an every other weekend father. The mediator leans in and strongly suggests he sign it. David, broken and exhausted, signs the binding term sheet just so he can go home. This is the exact moment men lose their divorces. In Washington state, this document is often referred to as a Civil Rule 2A agreement, and in Oregon, a binding settlement agreement. Once you sign your name to that piece of paper at the end of a grueling mediation session, it becomes a legally binding contract. The potential outcomes of trying to walk back a signed mediation agreement the next morning because you realize you made a terrible mistake are virtually zero. The court will enforce that rushed, exhaustion-induced contract with ruthless efficiency. Your strategy for this day must be ironclad. You must walk into mediation with a hard stop time established in advance. You must inform your attorney and the mediator that you will leave the building at exactly 5 in the afternoon. Regardless of where negotiations stand, to prevent late-night, fatigue-based decisions. You must bring your own food to maintain your physical energy. Most importantly, you must be mentally prepared to look the mediator in the eye, reject a bad deal, and confidently state that you are ready to proceed to trial. The willingness to walk away is the only true leverage you possess in that building. But what happens when you do walk away? What happens when mediation completely fails, and the court realizes that two parents are locked in an intractable war over their children? In the Pacific Northwest, the court's immediate response is to introduce a terrifying wildcard into your life. They will appoint a complete stranger, arm them with immense investigative power, and instruct them to dissect every single aspect of your character, your history, and your relationship with your children. Tomorrow, we are diving deep into the terrifying reality of guardian ad litems and custody evaluators, and how one subjective report from a state-appointed investigator can permanently erase you from your child's life, if you do not know exactly how to manage them. When mediation breaks down and the battle lines over your children are rigidly drawn, the court system in the Pacific Northwest will inevitably deploy its most potent and often misunderstood weapon. They will appoint a guardian ad litem or a specialized custody evaluator. To survive this critical phase, you must fundamentally understand exactly who this person is and the immense, almost unchecked authority they wield over your family. In Washington and Oregon, a guardian ad litem or custody evaluator is typically a private attorney or a licensed mental health professional contracted by the state. Their official mandate is to independently investigate your family dynamics, interview all relevant parties, and submit a formal written recommendation to the judge regarding what custody arrangement serves the best interests of the children. However, the operational reality that men must face in the year 2026 is that this single individual effectively becomes the judge. Family court dockets in counties like King, Pierce, and Multnomah are completely overwhelmed. Judges simply do not have the calendar time to listen to days of contradictory testimony from two angry parents arguing about who makes a better school lunch or who attends more pediatric appointments. Therefore, historical trends clearly show that judges will almost always rubber stamp the final recommendations made in the evaluator's comprehensive report. Your entire objective during this phase is to manage this investigator with flawless, emotionless precision. The most dangerous misconception men harbor when stepping into the evaluator's office is believing this person is a therapist, a counselor, or a sympathetic ear. They are absolutely not. They are a state-appointed investigator actively building a legal case file. Imagine if you are a man named James, a regional logistics director living in Seattle. James is deeply stressed, operating on 4 hours of sleep a night, and severely traumatized by the ongoing legal warfare and mounting financial strain. During his initial intake interview with the custody evaluator, James makes a catastrophic error. He treats the evaluator like a confidant. He vents extensively about his spouse's erratic behavior. He expresses his deep, paralyzing anxiety about his skyrocketing legal fees, and he openly admits to feeling overwhelmed by the entire process. James assumes that his vulnerability and transparency will make him look reasonable, honest, and human to the investigator. Instead, the evaluator meticulously notes James's high stress levels, flags his venting as evidence of a hostile co-parenting attitude, and documents his admission of being overwhelmed as a clear, potential inability to handle primary caregiving duties. Opposing counsel will later weaponize this exact vulnerability in court, framing James as emotionally unstable and unfit for equal parenting time. You must treat every interaction with an evaluator as a formal deposition. You remain calm, you remain strictly focused on the needs and routines of the children, and you never complain about the divorce process itself. The investigation will eventually move from the evaluator's office to your physical residence for the mandatory home visit. This is not merely a white glove inspection to ensure you vacuum the carpets and wash the dishes. It is a highly rigorous, active psychological assessment of your domestic environment. Evaluators are observing how your children naturally interact with you in your space. Are there age-appropriate books and educational materials readily accessible? Is the refrigerator stocked with healthy, routinely consumed food? Or does it look like a temporary bachelor pad filled with takeout boxes? Many men attempt to stage the perfect, flawless afternoon for the evaluator. They buy brand new, expensive toys the day before, and they hover anxiously over their children, dictating every activity to ensure it looks enriching and educational. Evaluators are highly trained to spot this artificial, performative behavior instantly. Case studies indicate that evaluators are looking for natural, established domestic routines. If your child asks where the extra toilet paper is kept, or where their favorite winter socks are, and you do not instantly know the answer, the evaluator immediately recognizes that you are not the primary domestic caretaker. You must know the intricate geography of your own home and the precise daily rhythms of your children flawlessly. Your home must reflect a lived-in, comfortable reality where you are clearly at the helm. Beyond your home, the evaluator will cast a wide net by interviewing collateral contacts. These are the teachers, pediatricians, daycare providers, and neighbors who routinely interact with your children. This represents a massive, often invisible vulnerability for fathers. If your spouse has spent the last 5 years taking the children to every single medical appointment and parent-teacher conference while you were at the office providing the financial foundation, the school and the doctor only know her. When the evaluator calls the pediatrician's office, the doctor will honestly and accurately report that the mother is the exclusive medical caregiver. You must proactively establish your undeniable presence with these collateral contacts long before the evaluator ever makes a phone call. You need to be the parent emailing the teachers about assignments, attending the midday dental cleanings, and showing up at the extracurricular activities. If you wait until the evaluator is appointed to suddenly start playing an active role in these areas, it will be accurately documented as a transparent legal strategy rather than genuine historical parental involvement. Furthermore, in high-conflict cases in the Pacific Northwest, custody evaluations frequently include standardized psychological testing, such as the Minnesota Multiphasic Personality Inventory. Men navigating the brutal stress of a divorce in 2026 frequently and unintentionally trigger the defensive scales on these complex diagnostic tests. You will sit in a quiet room to answer hundreds of true or false questions, and you will instinctively try to paint yourself as a flawless, stoic human being who never gets angry, never makes mistakes, and never harbors negative thoughts. These tests are specifically mathematically designed to catch this exact behavior. Answering in this manner flags you as highly defensive and lacking crucial self-awareness. In the final written report, the evaluator will translate this high defensiveness score as an inability to acknowledge your own parenting flaws, which is a massive red flag for courts prioritizing adaptable co-parenting. You must approach these tests with grounded honesty, acknowledging normal human frustrations while demonstrating clear emotional regulation. The culmination of this deeply invasive months-long process is a highly detailed, 50 to 100-page document submitted directly to the judge. Reading this finalized report is often the most agonizing, psychologically punishing experience of the entire dissolution process. It contains every out-of-context quote you uttered, every perceived minor parenting failure observed during the home visit, and every negative or neutral statement made by your collateral contacts. If this ultimate report recommends that you receive limited visitation, and your spouse receives primary residential custody, overturning that specific recommendation at a formal trial is an incredibly steep, almost vertically impossible uphill battle. You would be forced to hire your own independent psychological expert to critique the state's expert, adding tens of thousands of dollars to your already staggering legal bill, and dragging the hostile process out for another agonizing year. But let us assume you execute this phase perfectly. You navigate the custody evaluator flawlessly, you secure a highly favorable parenting plan, and you successfully maintain your equal 50-50 time with your children. You might understandably feel a fleeting sense of victory and relief. However, the legal system has one final, devastating mathematical trap waiting for you. Just because you have equal time and equal nights with your children does not mean you are shielded from crippling monthly financial obligations. Tomorrow, we are going to expose the highly complex and often deeply punitive child support calculation formulas used in the Pacific Northwest, and exactly how opposing attorneys legally manipulate the definitions of your total compensation and hidden income to extract maximum monthly payments, regardless of how many nights the children actually sleep under your roof. The most pervasive and financially destructive myth circulating among men facing divorce is the belief that securing a 50-50 physical custody arrangement automatically equates to paying zero child support. This is a fundamental misunderstanding of how the legal machinery operates in the Pacific Northwest. Both Washington and Oregon utilize specific variations of an income shares model to calculate child support obligations. This model is engineered on the premise that a child should receive the same proportion of parental income that they would have received had the parents remained living together. To achieve this, the state court combines the gross incomes of both parents to determine a baseline total household income. They then cross-reference this total number against a state-mandated economic table to find the baseline child support obligation. Finally, this total obligation is prorated between the parents based on their individual percentage contribution to the combined gross income. Therefore, if you earn 80% of the total household income and your spouse earns 20%, you are mathematically responsible for 80% of that baseline financial obligation, completely regardless of the fact that the children spend exactly half of their time living in your house. While the court may apply a residential credit to slightly offset the cost of having the children in your home, a significant, legally mandated transfer of wealth from the higher earner to the lower earner is a mathematical certainty. To maximize this wealth transfer, opposing counsel will launch a highly aggressive campaign to artificially inflate your perceived income while simultaneously deflating the income of your spouse. In family court, the definition of gross income is vastly different and far more expansive than the definition used by the Internal Revenue Service. It is not merely your base salary. Historical trends demonstrate that courts will include overtime pay, historical commissions, annual performance bonuses, car allowances, daily per diems, and the vesting of restricted stock units when calculating your total gross income. Imagine if you are Christopher, a regional sales director operating in King County in the year 2026. Christopher has a reliable base salary of $150,000. However, 3 years ago, during an unprecedented economic boom, he secured a massive one-time enterprise contract that generated an anomalous $100,000 commission. The current market in 2026 has significantly cooled, and his realistic commission projections are closer to $20,000. When calculating child support, his spouse's legal team will completely ignore his current, realistic projections. Instead, they will aggressively argue that the court must average his last 3 to 5 years of W-2 statements, demanding that his monthly child support obligation be permanently set based on a historical, artificially inflated income of $250,000. The potential outcome of this strategy is devastating, as it legally obligates Christopher to pay a monthly figure derived from money he is no longer actually earning. The burden of proof falls entirely on Christopher and his forensic financial experts to mathematically demonstrate to the judge why that anomalous high-earning year was a non-recurring event and should be excluded from the baseline calculation. The complexities compound exponentially when dealing with performance bonuses and corporate equity. Courts frequently treat these variable forms of compensation as unpredictable, yet subject to division. Opposing attorneys will routinely draft proposed orders demanding that a set percentage of all future bonuses be automatically transferred to your ex-spouse within 3 to 5 days of receipt. This presents a massive hidden tax trap. If a judge orders you to pay 30% of your gross bonus toward child support, but the government taxes that same bonus at a rate of nearly 40%, your actual net take-home pay is entirely decimated. You are effectively paying your ex-spouse with money the government has already taken from you. Your legal team must possess the technical proficiency to fiercely negotiate for net-based calculations, ensuring that any percentage applied to variable compensation is strictly calculated after all mandatory federal, state, and payroll taxes have been deducted. Conversely, you must aggressively scrutinize the income side of your spouse's equation. If your spouse holds a master's degree and possesses a highly marketable skill set, but chose to work part-time or exit the workforce entirely during the marriage, the income shares model demands that their potential earning capacity be factored into the mathematical formula. This introduces the concept of imputing income. Historical case studies show that family courts are increasingly willing to assign a phantom income to a spouse who is found to be voluntarily underemployed. To achieve this, your legal team must frequently hire a vocational expert. This expert will conduct an exhaustive analysis of your spouse's education, their historical work experience, the current labor market conditions in the Pacific Northwest for the year 2026, and the availability of open positions. If the vocational expert successfully demonstrates to the court that your spouse could easily secure a job paying $80,000 a year, the judge will impute that $80,000 into the child support formula, regardless of whether your spouse actually goes out and gets the job. This drastically reduces your prorated percentage of the total obligation. However, proving voluntary underemployment requires thousands of dollars in upfront expert witness fees and a highly aggressive litigation strategy. Furthermore, the The baseline child support transfer you pay every month is merely the foundational floor of your financial obligation. The proportional income split is legally applied to all extraordinary expenses, including agreed-upon extracurricular activities, private school tuition, tutoring, and all uninsured medical, dental, and vision expenses. If the court determines your proportional share of the income is 75%, you are legally bound to pay 75% of the travel soccer team fees, 75% of the orthodontic braces, and 75% of the out-of-network pediatric therapy. A common, devastating tactic employed by opposing counsel is drafting the final parenting plan with vague language that allows the mother to unilaterally enroll the children in expensive activities without your prior consent, immediately binding you to pay your 75% share. This creates an unpluggable financial hemorrhage. You must ensure your final legal orders include strict, ironclad mutual agreement clauses, legally requiring your explicit, written consent for any extracurricular expense exceeding a specific dollar threshold before you can be held financially liable. You have navigated the custody evaluation, you have mathematically defended your income, and you believe the logical administrative battle of the divorce is finally stabilizing. But what happens when logic is entirely abandoned by the opposing side? What happens when your spouse realizes they are losing their financial and custodial leverage and decides to deploy the single most destructive, legally sanctioned weapon available in the entire family court arsenal? Tomorrow, we are going to dissect the terrifying reality of ex parte domestic violence restraining orders and exactly how a single unverified, mathematically calculated allegation can result in you being physically escorted from your own home by armed police officers in a matter of minutes, completely obliterating your custody leverage before you even have a chance to defend yourself in a courtroom. The term ex parte is derived from Latin and translates to from one party. In the context of family law in the Pacific Northwest, it represents the most chilling suspension of due process you will ever experience in a civil courtroom. When your spouse files an ex parte petition for a domestic violence protection order, or what is known as a Family Abuse Prevention Act order in Oregon, they are walking into a courtroom completely alone. You are not notified in advance. Your attorney is not present. The judge only hears one highly curated, heavily rehearsed narrative. In the year 2026, the threshold to grant a temporary 2-week restraining order is shockingly low. The courts operate on a strict abundance of caution doctrine. If a judge denies a temporary order and someone is genuinely hurt the next day, that judge faces immense public and professional backlash, potentially risking their career and judicial seat. Therefore, historical trends dictate that judges will almost universally grant the temporary order based solely on a sworn signed declaration. Within hours of that signature, armed law enforcement officers are dispatched directly to your residence or your place of employment. You are typically given approximately 15 minutes to pack a single bag of essential clothing, surrender any firearms you legally own, and hand over your house keys. Imagine if you are a man named Robert, a mechanical engineer living in Vancouver, Washington. It is a Friday evening. You and your spouse engage in a tense verbal argument regarding the division of marital finances. Voices are undoubtedly raised, but at no point is there any physical contact, nor are any physical threats of violence made. Frustrated and exhausted, you step in front of the front door for perhaps 3 seconds to finish your sentence before leaving the house to cool off. You voluntarily go to a hotel for the weekend to de-escalate the situation. On Monday morning, while you are sitting at your desk at your engineering firm, 2 police officers arrive in the lobby to serve you with a domestic violence protection order. In her sworn declaration, your spouse alleged that you aggressively trapped her in the home, completely omitting the context of the argument, and stated she was in imminent fear for her physical safety. By simply standing in front of that door for 3 seconds, you inadvertently provided her legal team with the exact behavioral criteria required to allege coercive control and unlawful imprisonment under current statutory definitions. The immediate legal cascade of this temporary order is apocalyptic for your entire divorce strategy. First, you are instantly rendered homeless, forced to live out of an extended stay hotel or sleep on a family member's couch, while continuing to pay the mortgage on the home you are legally barred from entering. Second, you are strictly prohibited from communicating with your spouse, which functionally means you are entirely cut off from your children. If your 7-year-old child calls your phone crying and asking where you are, and you answer that phone call, you have just committed a mandatory arrest criminal offense. Third, this order triggers an automatic, devastating shift in your custody dynamic. Your spouse is instantly granted temporary sole physical and legal custody. The parental status quo we discussed in earlier chapters is violently and legally reset in her favor. Furthermore, the psychological impact on your children is profound. They watch armed police officers remove their father from the home, cementing a terrifying narrative that you are dangerous and the home is only safe when you are removed. Opposing counsel knows exactly what they are doing when they deploy this tactic. This is rarely about actual physical safety. Historical case studies suggest it is a calculated, tactical nuclear strike designed to secure exclusive possession of the marital residence and immediate, uncontested child custody leverage. The danger absolutely does not stop at the physical separation. In our highly connected digital reality of 2026, men frequently and accidentally violate these temporary orders through sheer technological ignorance, resulting in immediate incarceration. If you share a cellular family plan and you log into the administrative portal to check the billing statements, opposing counsel can and will argue you are digitally stalking your spouse's communications. If you have a shared cloud storage account and a photo automatically syncs from her device to your tablet, it can be construed as prohibited third-party contact. Even a simple, accidental pocket dial to your home landline while your phone is in your jacket will result in a warrant for your arrest. You must immediately sever all digital ties, completely disable all location sharing applications, and often hand your primary devices to your legal team to ensure complete, verifiable, forensic compliance. The psychological pressure to reach out to your children during this mandatory blackout period will be agonizing. But you must understand that yielding to that fatherly emotion will result in criminal charges that will permanently destroy your family court case, and potentially your career. You are now operating on a highly compressed, intensely stressful 14-day timeline. The court will schedule a full evidentiary return hearing to determine if this temporary order should be extended for a full year, or in some severe cases, made permanent. This hearing is your one and only opportunity to defend yourself and reclaim your life. You cannot simply walk into that courtroom, take the stand and say she is lying. You must present an overwhelming, surgically precise avalanche of objective, undeniable evidence. This is where digital forensics becomes your absolute lifeline. Your legal team must immediately subpoena home security camera footage, download the metadata from your vehicle's GPS to definitively prove you were nowhere near the home when the alleged incident occurred, and compile a comprehensive, time-stamped audit of all text messages and emails to demonstrate a pattern of normal, non-threatening communication leading up to the surprise filing. You are essentially forced to finance and build a robust criminal defense case within the framework of a civil family law proceeding. If you and your legal team successfully expose the allegations as a tactical fabrication, the judge will dissolve the temporary order and allow you to return home. However, the damage to your reputation, the massive financial drain of emergency legal fees, and the trauma inflicted on your children has already been actualized. Many men naturally expect the judge to fiercely punish the spouse for committing perjury on a sworn declaration. Historical trends show a deeply frustrating reality. Family court judges in the Pacific Northwest rarely sanction mothers for filing false domestic violence petitions, often citing on the record that they do not want to create a judicial chilling effect that might deter genuine victims of abuse from seeking future court protection. You survive the ambush, you clear your name, but your spouse faces zero legal or financial consequences for deploying a weapon that nearly destroyed your life. You have fought your way back into the marital home, you have cleared your name of false criminal allegations, and you have temporarily stabilized the financial bleeding. You might think the worst of the overt legal warfare is finally behind you, but overt courtroom warfare is easy to spot and defend against. What happens when the tactics shift from the judge's bench to the living room couch? What happens when your spouse realizes she cannot legally remove you through the police, so she decides to psychologically remove you from the minds of your own children? Tomorrow we are going deep into the darkest, most insidious psychological phenomenon in the entire family court system. We will dissect the exact, step-by-step mechanics of parental alienation, and how seemingly innocent, everyday comments made by your ex-spouse can systematically reprogram your children to despise the very sight of you. Parental alienation is rarely an explosive cinematic event that you can easily record and show to a judge. Instead, historical trends in family psychology describe it as a systematic, insidious campaign of covert emotional manipulation. It is the slow daily drip of psychological poison designed to sever the biological and emotional tether between you and your child. In the highly complex family court systems of the Pacific Northwest, proving this phenomenon is exceptionally difficult because the alienating parent rarely uses direct, aggressive language. They do not look at the child and explicitly command them to hate you. If they did, it would be easy to expose. Instead, they rely on microaggressions, subtle guilt trips, and the weaponization of the victim narrative to make the child feel entirely responsible for the mother's emotional stability. Imagine if you are a man named Mark, a software architect living in Bellevue, Washington, navigating the family court system in the year 2026. Mark shares equal custody of his 10-year-old daughter, Sarah. When Mark calls Sarah on his designated Tuesday evening, the alienation is not overt. The mother answers the phone, lets out a long, highly audible sigh of absolute exhaustion, and hands the device to the child, whispering loudly enough for the microphone to pick it up, stating that she will be waiting right outside the door if Sarah needs to be rescued. In that 3-second exchange, the mother has artificially manufactured a crisis. She has communicated to the 10-year-old that talking to her own father is a dangerous, exhausting ordeal that she must endure, and that the mother is the only safe protector. When Sarah goes to Mark's house for the weekend, the mother packs her bags with tearful goodbyes, hugging her as if she is being sent to a war zone, and telling her to be brave. By the time Sarah walks through Mark's front door, her nervous system is completely dysregulated. She is anxious, she is hostile, and she views her father not as a parent, but as the source of her mother's profound suffering. This psychological reprogramming extends heavily into the financial realm, which is a brutally effective tactic in high-asset tech sector divorces. If Mark declines to pay for an exorbitant, non-essential luxury item that falls entirely outside the legally mandated child support agreement, the mother will not explain the concept of budgeting to the child. Instead, she will weaponize the boundary. She will look at her daughter and say they cannot afford the item because her father is financially withholding money to punish them, completely omitting the fact that Mark pays $4,000 a month in baseline support. The child is forcibly adultified. She is pulled out of the innocent ecosystem of childhood and drafted as a frontline soldier in an adult financial war. She lacks the cognitive development to understand. The potential outcomes of this sustained campaign are scientifically predictable and deeply tragic. The child will eventually succumb to a psychological defense mechanism known as splitting. Because the pressure of loving two parents who are at war is too emotionally agonizing, the child's brain protects itself by categorizing one parent as entirely good and the other parent as entirely evil. Once this psychological break occurs, you will notice a terrifying shift in your child's vocabulary. Sarah will stop using the language of a 10-year-old. She will suddenly begin reciting highly sanitized, clinical adult phrases. She will tell Mark that she needs space, that he is toxic, that he is failing to respect her boundaries, and that he makes her feel unsafe. These are not the words of a child. This is a recorded playback of the alienating parent's internal script. When men finally recognize this happening, they almost universally make a fatal strategic error. Driven by heartbreak and desperation, they attempt to logically argue with the child. They pull out bank statements to prove they are paying child support. They try to explain the complex legal truths of the divorce. This is a catastrophic miscalculation. By arguing with the child, you are inadvertently validating the mother's narrative. You are raising your voice, you are becoming visibly frustrated, and you are proving to the alienated child that you are exactly the hostile, unstable figure the mother warned them about. The legal system in the Pacific Northwest frequently fails men in these exact scenarios. Family court judges and standard custody evaluators often confuse parental alienation with estrangement. Estrangement is a justified rejection of a parent due to actual, documented abuse or severe neglect. Alienation is an unjustified, heavily programmed rejection. When an evaluator interviews an alienated child in Multnomah County or King County, the child will aggressively state that they never want to see their father again. Many overworked evaluators will take this stated preference at face value, concluding that forcing the child to see the father will cause unnecessary trauma. They fail to look beneath the surface to identify the psychological puppet master pulling the strings. In the year 2026, courts are highly sensitive to the concept of bodily autonomy and the voice of the child, particularly as they approach the ages of 12 to 14. Alienators are acutely aware of this judicial timeline, often accelerating their campaigns precisely as the child ages into legal relevance, knowing the judge will likely rubber stamp the child's brainwash demands. Historical case studies indicate that the only viable countermeasure to this invisible warfare is the immediate introduction of a highly specialized forensic psychologist who is explicitly trained to differentiate between estrangement and alienation. You cannot rely on a standard family therapist. A traditional therapist operates on a model of validating the client's feelings. If an alienated child tells a standard therapist that their father is terrifying, the therapist will validate that feeling, unwittingly cementing the delusion and permanently entrenching the alienation. You must legally petition the court to appoint an expert who understands the pathology of enmeshment and coercive control. Furthermore, your personal conduct must become an impenetrable fortress of stoicism. You must absorb the hatred and the rejection from your own child without ever reacting in anger, consistently modeling unconditional love and unshakable stability, creating a living contrast to the terrifying monster the mother has painted you to be. Documenting this psychological abuse requires immense endurance, thousands of dollars in expert fees, and a legal team capable of articulating complex psychiatric concepts to a judge who is staring at a clock and managing 20 other cases that morning. But what happens when the mediation has failed? The evaluators have submitted their deeply flawed reports, the alienation has reached a fever pitch, and the administrative machinery of the family court can no longer contain the conflict. What happens when you are finally forced to step into the fluorescent light of a courtroom, place your hand on a Bible, and fight for your financial survival and the very soul of your children in front of a completely unpredictable judge? Tomorrow we are going to expose the brutal, unforgiving mechanics of a formal family law trial, the terrifying reality of cross-examination, and exactly how opposing counsel will attempt to legally assassinate your character on the public record. Stepping into a formal family law trial in the Pacific Northwest is the jarring realization that the justice system is not a sanctuary for the truth, but an incredibly rigid, administrative battlefield governed by the sterile rules of evidence. If you have spent the last 12 to 18 months surviving temporary orders, navigating brutal mediation sessions, and enduring invasive custody evaluations, you might harbor a desperate, lingering hope that the trial is your ultimate opportunity to finally tell your side of the story. You imagine looking the judge in the eye and explaining the entire complex, nuanced history of your marriage. This is a massive, highly destructive misconception. In the year 2026, family courts in jurisdictions like King County, Pierce County, and Multnomah County are operating under unprecedented systemic backlogs. Judges are frequently managing dockets with hundreds of active cases. They do not have the time, the patience, or the legal mandate to listen to your emotional narrative. A trial is strictly an evidentiary proceeding. It is a mechanical process of admitting documents, authenticating financial records, and answering highly controlled questions. If your spouse has been secretly draining a joint checking account, but your legal team fails to properly authenticate and submit those specific bank statements according to the strict local rules of evidence, that theft mathematically and legally does not exist in the eyes of the court. The absolute climax of this sterile environment, and the most psychologically grueling experience a man will face during the entire dissolution process, is cross-examination. When you take the witness stand, your own attorney will first conduct direct examination. This consists of open-ended questions designed to let you introduce your financial documents and state your desired parenting plan on the official record. It is relatively calm and highly rehearsed. However, the exact second your attorney sits down, opposing counsel will approach the podium, and their singular professional objective is to publicly and legally assassinate your character. Opposing counsel is not there to ask you open-ended questions. They are there to utilize a deeply aggressive tactic known as leading questions. A leading question is an accusation masquerading as an inquiry, specifically engineered to force you into a corner where you can only answer yes or no. They will meticulously dissect your past text messages, your emails, and your financial declarations, stripping away all context to paint you as a negligent father, a financial abuser, or an unstable, angry individual. Imagine if you are Thomas, a senior project manager living in the suburbs of Portland. During the marriage, Thomas worked demanding 60-hour weeks to single-handedly fund the family estate, pay the mortgage, and maintain fully funded college savings accounts for his 2 sons. Because of his intense corporate travel schedule, his spouse handled the majority of the weekday doctor appointments and school pickups. On the witness stand, opposing counsel will not ask Thomas to describe his role as a provider. Instead, they will launch a rapid-fire, highly aggressive sequence of leading questions. They will ask, "Is it true you missed your son's dental appointment on October 12th? Thomas will instinctively want to explain that he was closing a massive contract in another state that secured his annual bonus, which paid for that exact dental procedure. But before he can utter a single word of that critical context, opposing counsel will raise their hand, look at the judge, and demand that the witness be instructed to answer only yes or no. The judge will look at Thomas and order him to answer the question directly. Thomas is forced to say yes. Opposing counsel will then immediately ask, "Is it true you also missed the parent-teacher conference on November 4th?" Again, Thomas is forced to say yes. Within 60 seconds, opposing counsel has weaponized Thomas's financial sacrifices, twisting his role as the primary breadwinner into a public admission of historical parental neglect on the permanent court record. The ultimate goal of this aggressive questioning is not just to establish a negative factual record. It is to trigger a real-time, visible emotional reaction that the judge will observe and penalize. Opposing attorneys are masters of psychological warfare. They know that the stress of a divorce completely frays the human nervous system. They will intentionally mock your financial contributions, they will belittle your bond with your children, and they will subtly roll their eyes at your answers. They are actively trying to make you angry. Historical trends in family court show a deeply ingrained systemic bias regarding male anger. If a mother cries or raises her voice on the witness stand, it is almost universally interpreted by the court as the natural, sympathetic distress of a protective parent. If a father raises his voice, points a finger, or displays visible frustration during cross-examination, he is instantly categorized as hostile, aggressive, and potentially unsafe. If you allow opposing counsel to make you lose your temper on the stand, you have handed them the exact psychological profile they need to mathematically decimate your parenting time. Surviving this ordeal requires immense, almost unnatural emotional control. The most effective defense mechanism against cross-examination is the mandatory 3-second pause. When opposing counsel fires a hostile, deeply insulting question at you, you must completely detach from your ego. You must silently count to 3 in your head before opening your mouth. This pause accomplishes 3 critical legal objectives. First, it ensures you are not interrupting the lawyer, which angers the judge. Second, it gives your own attorney the crucial window of time. They need to voice a legal objection before you accidentally answer an improper question. Third, and most importantly, it forces your brain to bypass the emotional, reactive amygdala and engage the logical prefrontal cortex. You must deliver your answers in a flat, clinical, entirely emotionless tone. You must become a biological machine dispensing only facts. Beyond your own testimony, the trial will feature the deeply complex and incredibly expensive battle of the expert witnesses. If you are dealing with unvested restricted stock units from a major Seattle tech firm, your forensic accountant will take the stand to explain the time rule formula and defend your separate property claims. Opposing counsel will then cross-examine your accountant, attempting to prove their mathematical methodology is inherently flawed. The judge, who is a legal expert but rarely a financial expert, is left to decide which highly paid accountant is telling the truth. The potential outcomes of this single day of expert testimony can literally dictate the trajectory of your retirement portfolio for the next 20 years. Similarly, if a custody evaluator was appointed, they will be cross-examined regarding the subjective conclusions in their report. Attempting to overturn an evaluator's recommendation during trial is statistically one of the most difficult feats in family law, requiring your attorney to systematically prove that the evaluator violated standardized psychological testing protocols or ignored massive amounts of collateral evidence. When the final witness is dismissed and the attorneys deliver their closing arguments, there is rarely a dramatic, cinematic conclusion. The judge will not bang a gavel and instantly declare a winner. Instead, they will simply state that they are taking the matter under advisement. You will walk out of the courthouse completely exhausted, having spent hundreds of thousands of dollars, and you will wait. In backlog jurisdictions, you might wait weeks or even months to receive a finalized written ruling in the mail. When that ruling finally arrives, establishing the permanent parenting plan and the final division of assets, you might feel a fleeting, overwhelming sense of relief that the war is finally over. But this is the ultimate, devastating illusion of the family court system. The signing of a permanent order does not end the conflict. It merely resets the rules of engagement. What happens when, 12 months after the trial concludes, your former spouse unilaterally decides she wants to move 3 states away and take your children with her? What happens when she intentionally quits her job to file a legal petition demanding a massive, crippling increase in your monthly child support obligations? Tomorrow, we are exposing the endless, terrifying labyrinth of post-judgment litigation, the strategic weaponization of modification petitions, and exactly how to bulletproof your life against a former spouse who simply refuses to stop fighting. The ink on your final divorce decree is barely dry, and you are operating under the dangerous assumption that the legal warfare has permanently concluded. This is the illusion of the final order, In the family court systems of Washington and Oregon, a finalized parenting plan and child support order are not static documents. They are living, breathing legal frameworks that remain active until your youngest child turns 18 or graduates from high school. This creates an environment highly susceptible to post-judgment litigation. Historical trends demonstrate that highly conflict-driven former spouses will frequently utilize the legal mechanism of modification petitions to continuously disrupt their ex-husbands, dragging them back into the courtroom year after year to drain their newly rebuilt financial reserves and slowly chip away at their parental access. You must understand that the family court system rarely penalizes individuals for filing excessive motions, which effectively allows a motivated former spouse to utilize the legal system as a tool of perpetual, legally sanctioned harassment. The single most terrifying post-judgment weapon in the Pacific Northwest is the notice of intent to relocate. Imagine if you are a man named Daniel, a cybersecurity consultant living in Seattle in the year 2026. You survived a brutal custody battle and secured a highly favorable residential schedule with your 8-year-old daughter. You purchased a smaller house in the exact same school district to ensure maximum educational stability. 18 months later, you receive a certified letter in the mail. It is a formal legal notice from your former spouse stating she intends to relocate to Boise, Idaho, or Austin, Texas. She claims the cost of living in King County is too high and she has family support in the new state. She is legally informing you that she plans to take your daughter with her, effectively reducing your role to a summer and holiday visitor. The geographic reality of the modern economy means people are highly mobile, but when children are involved, a state border becomes an impenetrable wall dividing you from your child's daily life. The statutory frameworks governing relocation are aggressively fast and historically unforgiving. In Washington state, if a primary or joint residential parent intends to move outside of the child's current school district, they must provide formal legal notice. The exact moment that notice is served, a terrifying countdown clock begins ticking. You typically have exactly 30 days to file a formal objection and petition the court to block the relocation. If you miss that strict 30-day window because you thought you could negotiate with her privately, or because you simply froze in panic, the court will automatically permit the move by default. When you do successfully file the objection, the legal battle that follows is arguably more intense than the original divorce trial. The courts will heavily scrutinize the underlying reasons for the move. Is it a legitimate, verifiable career advancement, or is it a bad faith attempt to geographically alienate the father? Historical case studies reveal that judges face an incredibly difficult balancing act in these scenarios. They must weigh the mother's constitutional right to travel against the child's established right to maintain a meaningful, daily relationship with their father. To defeat a relocation petition, your legal team must systematically dismantle the opposing arguments, proving that the move fundamentally disrupts the child's established educational stability, their medical care team, and their daily bond with you, demonstrating that the severe detriment to the child vastly outweighs any hypothetical benefit to the mother. Even if you manage to legally keep your children in the same zip code, the financial battlefield is equally volatile due to child support modification petitions. The income shares model we analyzed previously is highly sensitive to the economic fluctuations of 2026. If your ex-spouse discovers that you received a significant corporate promotion, or if the technology sector experiences a sudden boom and your restricted stock units skyrocket in value, she can legally file a motion to forcibly audit your new financial records and demand a massive upward modification of your monthly support obligation. However, the far more insidious tactic involves the deliberate deflation of her own income. Consider a scenario where your former spouse successfully retains a high-paying marketing position during the initial divorce. 2 years later, she voluntarily quits her job, claiming she wants to go back to graduate school to completely change careers, or she decides to take a low-paying part-time job to reduce her stress. She then files a modification petition demanding that you instantly cover the massive mathematical deficit she just created by abandoning her earning capacity. To combat this calculated financial maneuvering, you must rely on the protective measures your legal team embedded into your original decree. This is exactly why aggressive, uncompromising litigation during the initial divorce is paramount. If you successfully negotiated an imputed income clause during the original settlement, legally establishing that she is capable of earning a specific salary regardless of whether she actually chooses to work, you possess a massive defensive shield. When she files the modification claiming poverty, your attorney simply points back to the original decree, arguing that her underemployment is strictly voluntary and you are not legally obligated to underwrite her personal lifestyle choices. Without that specific legal language permanently cemented in your final orders, you are forced to relitigate the entire vocational evaluation process from scratch, paying thousands of dollars to new experts to mathematically prove she is intentionally avoiding gainful employment. Bulletproofing your life against continuous post-judgment litigation requires adopting a permanent mindset of radical, heavily documented compliance. You must never give your former spouse an inch of administrative leverage. You pay your child support exclusively through the state registry, so there is an absolute, undeniable mathematical record of every single transaction. You communicate exclusively through court-approved co-parenting applications, ensuring every single message is time-stamped, unalterable, and perfectly formatted for a judge to instantly review. You never agree to informal, verbal modifications of the parenting plan. If she asks to swap weekends or adjust holiday times, you require the agreement explicitly in writing. If she continually breaches the parenting plan by showing up hours late for custody exchanges or intentionally denying your scheduled phone calls, you do not simply get angry. You meticulously log every single violation. When she inevitably files a frivolous motion against you, your legal team uses that comprehensive, emotionless log to file a motion for contempt, demanding that the judge formally sanction her for her continuous, documented pattern of bad faith behavior. You have survived the initial separation. You have mathematically secured your remaining assets. You have fought back the psychological warfare of alienation. And you have built an impenetrable administrative fortress to defend against endless post-judgment attacks. You are financially bruised but structurally intact. You have maintained your relationship with your children. But surviving the legal machinery is only half of the equation. Once the lawyers pack their briefcases and the court file is finally sealed, you are left staring at the remnants of your former life, facing the terrifying prospect of starting completely over in a culture that often views divorced men with deep suspicion. How do you aggressively rebuild your wealth from ground zero in your 40s or 50s? How do you introduce a new partner into a highly fragile, recovering family dynamic without triggering a catastrophic relapse of legal warfare? Tomorrow, in the final chapter of this masterclass, we are completely shifting focus from legal survival to total personal resurrection. We will map out the exact blueprint for rebuilding your psychological resilience, aggressively compounding your remaining capital, and reclaiming the life that the family court system tried so desperately to dismantle. Rebuilding psychological resilience is not a passive process of simply letting time heal wounds. In the immediate aftermath of a highly litigated divorce in the Pacific Northwest, men experience a phenomenon that forensic psychologists often refer to as the silent apartment syndrome. You have spent the last 2 years hypervigilant, analyzing every text message, consulting with attorneys, and preparing for the next catastrophic legal filing. Suddenly, the legal machinery stops. You are sitting alone in a newly rented apartment, and the silence is deafening. Historical trends in male psychology post-dissolution indicate that this exact moment is where the highest risk of systemic depression occurs. Men frequently tether their entire core identity to the dual roles of husband and primary provider. When the court system mathematically redefines you as a non-custodial visitor and forcibly redistributes the wealth you generated, that core identity is shattered. Imagine if you are a man named Jonathan, an aerospace engineer in Pierce County. Jonathan survived the trial but lost the marital home. He spends his first weekend alone staring at the walls, completely paralyzed by a profound sense of injustice. The path to psychological resurrection requires what clinical experts define as radical acceptance. This is not forgiveness and it is not forgetting. It is the cold, analytical acknowledgement that the family court system is a flawed administrative bureaucracy, not a moral arbiter of your worth as a man or a father. Jonathan had to actively sever his emotional attachment to the past. He stopped agonizing over the equity in a house he no longer owned and ceased expecting his former spouse to suddenly behave rationally. By embracing radical acceptance, he redirected the immense mental energy previously consumed by anger into highly structured, future-focused actions. This psychological pivot is the absolute mandatory foundation for everything that follows. With your psychological baseline stabilized, you must immediately transition to aggressive financial reconstruction. The mathematical reality of a divorce in 2026 is that your balance sheet has likely been decimated. You are effectively starting from scratch, but you are doing so with a massive, recurring monthly liability in the form of child support or spousal maintenance. The traditional financial advice of slowly saving 10% of your income is entirely insufficient for this new reality. You must adopt a strategy of aggressive capital compounding. Let us examine a historical case study of a man named David, a senior developer at a major technology firm in Washington state. During the property division phase, David surrendered 50% of his vested stock options and the entirety of his retirement accounts to offset his spouse's claim on the home equity. At 45 years old, his retirement trajectory was completely derailed. David recognized that to survive, he had to temporarily lower his baseline standard of living far below his actual income bracket. He rented a modest townhome, drove a reliable, depreciated vehicle, and systematically funneled every single post-tax dollar, every annual bonus, and every newly vesting restricted stock unit into highly diversified, aggressive index funds. Furthermore, he meticulously tracked his new tax reality. As a single filer with massive non-deductible legal debts, his tax liability had fundamentally shifted. By consulting with a specialized certified public accountant, David utilized advanced tax loss harvesting strategies and maximized his catch-up contributions to shield his remaining capital from further depletion. The potential outcomes of this hyper-disciplined approach are profound. Within 5 years, historical financial modeling shows that a man operating with this level of ruthless financial efficiency can often surpass the net worth he held prior to the divorce, precisely because he is now the sole architect and beneficiary of his financial ecosystem. As your psychological health and financial balance sheet begin to recover, a new variable inevitably enters the equation, which is the introduction of a new romantic partner. This is where the legal ghosts of your past will violently attempt to drag you back into the courtroom. In the Pacific Northwest, particularly in equitable distribution states like Oregon, cohabitation is a massive legal tripwire. If you are paying compensatory spousal support, your former spouse's legal team is actively waiting for you to make a mistake. Imagine you have been dating a highly successful professional for a year, and you decide to move in together to split living expenses in Multnomah County. The exact moment your names appear on the same lease, or you begin sharing utility bills, your former spouse can legally file a modification petition. She will argue that because your living expenses have decreased due to cohabitation, your disposable income has mathematically increased, and therefore, her monthly spousal support should be significantly adjusted upward. Alternatively, if she is the one paying you support, she will argue that your new partner is financially supporting you, attempting to completely terminate her obligation to pay. The complexity accelerates exponentially when you introduce this new partner to your children. You must execute this transition with tactical precision. If you rush the introduction, or if your new partner immediately attempts to assume a disciplinary or maternal role, it will trigger an immediate, explosive reaction from your former spouse. She will likely file an emergency motion claiming the new partner is a disruptive influence. Utilizing the exact parental alienation tactics we previously dissected to weaponize the children against your new relationship. To prevent this, your boundaries must be impenetrable. Your new partner must understand that she is entering a highly volatile ecosystem. You must maintain separate financial accounts, never commingle assets without a highly restrictive legal cohabitation agreement, and strictly enforce the established parenting plan without allowing your new partner to negotiate on your behalf. You are no longer just a father. You are the chief executive officer of your newly restructured life, and you must protect the borders of that life with absolute vigilance. You have navigated the psychological destruction, the financial audit, the custody evaluation, the trial, and the post-judgment ambushes. You possess the blueprint to rebuild an extraordinary life from the ashes of the family court system. But what happens if you decide to get married again? How do you guarantee that you never have to endure this brutal, wealth-destroying process a second time? Next week, we are launching an entirely new, highly intense masterclass on the exact mechanics of modern prenuptial agreements, and how to legally engineer an ironclad contract that completely overrides the family court system before you ever say I do.